All right, well, can you guys all hear me okay? Good evening. Actually, Bob Riley's here. He knew me when I was in Lewistown. I grew up on a ranch in Zortman, then Browning, and then Lewistown. I rodeoed for years, and we lost our ranch when I was in college, so I went to horseshoeing school. And so I bartended and shod horses to pay for college. And at one point, my dad said, Hertha, you should use your brain, not your brawn. And I said, surely, Dad, I would starve to death. And so since then, I just quit shoeing my horses a couple of years ago. I still trim them, but I hire the horseshoer to shoe them, and I like it. And anyhow, I left Montana and got a journalism school after I managed a ranch for a while. I was a pre-vet, pre-med student, then took time off, and I went to journalism school at Temple. And then I covered Congress working for Washington, the National American Farm Bureau Federation. And while I was there covering Congress as a journalist, I did cover a case on Supreme Court on property rights. And as I watched that case, I said, I want to protect property rights. You know, we lost our place. We lost it because of the economy, not because somebody took it. But for me, true north is protecting people and their property rights. So for the last 30 years, I've been all across the West doing property rights type issues. And I probably have done more wind leases. I've done wind leases for at least 20 years. Than I think any other practicing attorney in Montana, because I did them in Wyoming, and then when I moved here. So I've done many of them on behalf of landowners. So what I'm going to share with you tonight is we're going to go through a couple documents, and I'm going to show you what I look for. Now, I'm not giving you legal advice. Has everybody got that? It's not legal advice. This is education. Because your circumstance could be different. I'm not going to hold back. I'm going to tell you, just like if you were sitting with me and I was giving you education about what your document does. I do not have a position for or against wind farms. I do have a position that I want to educate you the best I can so you can make the best decision for you in your place. So that's my job tonight. I would actually, during the conversation, or during my talk, it is a conversation. If you want to ask me questions, that'll be great. If I think we're not going to get through both documents, it's getting off, I might pull it back in. Because remember, I used to line up 7 horses and shoe them all. So if I think I need to line things out so we can get the project done, I might do that. But otherwise, this is a conversation. And for the people on Zoom, are you hearing me okay, Steve? Okay. I will repeat the question. If somebody here asks me a question so you can hear it. We're not going to be able to do questions for you or with you, but I'm sure this room is full of very smart, intelligent people, and I'm sure they're going to ask me hard questions, and I may know half the answers. So tonight we're going to start. Let's just get right into it. I'm going to go through 2 documents. The latest one, the first one I'm going to do is a 2024 document that somebody who's building, did you say south of here? East of here, that some company who's putting together a project to do a wind farm. I'm going to tell you exactly what I see in this document. Some of it will be good, some of it will be bad. I am not giving you advice on whether you should do a deal with them or not. That is not my job tonight. And even if you hired me, I wouldn't tell you whether or not you should do the deal. I would tell you what the contract does, okay? So the first thing I do when I look at this, in Montana, property rights, we have, this document says option, lease, and easement agreement. So that means it's an option, which means they have time to be able to enact their option. So you have, when you sign this, you've come to terms on what your agreement will be, but they have, I think in this case, it's up to 8 years, 7 years to be able to pull the trigger on the option. It's also a lease and an option agreement. If you ever see a wind lease that doesn't say lease and easement, then whoever you're doing with doesn't know how to do business in Montana. And that's because, think of property. We know that real property is land. You can describe it by meets and bounds and a legal description, or you can use your address. That's ways you can describe what your property is. When you own the property in fee simple, you own all the rights to all the uses for that property. If you own the mineral rights, you own the mineral rights into the ground. But supposedly you own above into the air. So all the uses that go with that, if you own fee simple, is yours. There's sticks in the bundle of the sticks is the way we think about property. And so one stick in the bundle of sticks might be that you lease you have a gravel, some type of gravel pit arrangement. So that's one use that you lease to someone else. You might lease out your cattle grazing. So that's a lease. An easement, though, if you want somebody to have an access across that property, you have to give an easement. And you do a legal description of that, or somebody could have it because they've been using the road without permission for a certain amount of time. So there's other ways you can get an access easement, but it is an easement. And an easement is more than a lease. It runs with the property, which means after you sell the property, your easement goes with it. So in Montana, the use of wind for the turbines to turn into electricity, that's an easement. So a wind agreement has to have a lease of the land, has to have an easement of the access rights. It has to have the easements for the ability to turn the air through the turbines and make energy from it. That's an easement. Also easement for roads and anything else they need to be able to get in and out. So that's the first thing I look at. And before, there were a lot of documents that they brought in before I gave them an education where they just called them leases, and that's not suitable for Montana. So this tells me that this company at least knows they're in the state of Montana where you have to have an easement to do the wind and get access. The next thing I look at, now look, when I'm doing this for a landowner, I'm looking at many things and I'm getting an assessment of whether I think this company, how they do business. So what they do in their document tells me a lot. In general, I would say this document, it's with Veritas, it's a 2024 document, is landowner light. If you brought me this document, I would say there's some things that I would advise you that we negotiate and fix. This document has things that I would prefer to be different on your behalf. So the option term is 5 years, but then they have some ways where they can go for another 2 additional year and another year. So that it's like, even as a lawyer, I don't do math very well, except for my hours. It's 8 years. So the other thing, there's a lot of stuff that's just standard. I'm not going to go through every term. I'm going to tell you, when you sign this document, if you're a landowner, yes, you're going to get paid a certain amount if they ever put up wind turbines, so they're going to pay you a certain amount per acre before they put turbines up. That's important. But the most important thing are the clauses that if something went wrong, you could lose the ranch. Those wind farms, those turbines are probably each worth somewhere between $1.5 to $3 million. I have not ground truthed my numbers in the last 10 years. The more the turbines increase in size, the more value they have. But let's just say I'm right that they're worth $3 million. Let's say you get 10 turbines. Well, 3 times 10, that's all of a sudden you've got $30 million of their assets, and that's just the turbines on your property. I know some of you guys own a lot of property, but I'm not sure many of you have $30 million worth of property. That means that the assets of the wind company significantly dwarf the assets of the landowner. So when I'm looking at this on behalf of landowners, I'm doing everything I can to make sure that if something goes wrong, here you go, you were so good-hearted, you did a deal with a wind company, and then something goes wrong and you lose the whole place. That's not really good business. So my job first is to get a document that if you do sign it, that you're protected. So that's what I'm looking for first. So I'm now on, Jackson, I'm on already to page 3. So in paragraph number 5, they talk about the term. And this one is, it says its initial term of 50 years, and then it's 2 additional terms of 10 years. Well, that's 70 years. I'm not sure, I'm pretty sure I'm not going to be around in 70 years. So that's a long time lease. And most of these are at least 50 years, but 70 is at the far end of how long they usually are. Not to say that I've never seen one before for 70 years, but this is long. It's also a very long option period. So you have to be aware when you enter into one of these that you're going to pass it on to your heirs or whoever buys the place from you. You cannot keep the benefits for a wind agreement it goes with the property. So if you have one and you sell your land, the wind agreement goes with whoever buys the land. You cannot, it's not like mineral rights. You can't bifurcate it, okay?
So are you saying we can't get royalty payments off of it?
That's correct.
I don't know if this is the appropriate place, but this is a really long-term lease. Do the payments, are they ever adjusted for inflation? I mean, 70 years is a long time. 70 years ago, $1,000 was a hell of a lot of money, and today it buys you a couple tires.
Could you guys hear that question? Go ahead and tell me by raising. Okay, Steve says yes. So most agreements do have some type of accelerator clause that ties it to CPI. Does that sound right?
Could be.
Yeah, consumer price index. And now you're making me pull things out of I don't look that old, but I'm a little bit old. Any other questions right now? Are you all with me? All right, so next we'll go to, the next is we're going to talk on page 5, clause 7.72.2, 7.7.2. And this is hunting. You'd be surprised how much time on these wind agreements I spend on hunting. These wind farms, they must have people that shoot each other because they're very, very worried about doing a wind farm out here. And I'm like, you know what? We don't lose very many people to getting shot during hunting season. Every once in a while, somebody might shoot themselves or someone else in the Safeway parking lot, but we just don't hear about those accidents out here. We look before we shoot, but they're very, very worried about it. So this one says that the landowner has the right to hunt, but then it says, provided, however, whenever you see provided, however, read carefully. Damage however, such hunting activities are not permitted to interfere with grantee's use of the property, damage any improvements or other property belonging to grantee or a grantee party, or endanger or injure any grantee party. So here we have damage, endanger, injure, but then landowner shall indemnify. Whenever you see the word shall indemnify, be very careful. Call your lawyer. Landowner shall indemnify grantee from any such. I was just thinking, it's a good thing I didn't do this from the client because they have a confidentiality clause. But I think we can talk about the agreement. That's interesting.
They didn't sign it.
No, it's not signed. Yeah, so it's like, I have no idea where I got this. So. Oh my. You shouldn't think about these things in the middle of your talk, Hertha. Okay, so landowner shall indemnify grantee from any such interference, damage, or injury. So now they want the landowner to indemnify. That means that if anything goes wrong, the landowner has to take care of it. If somebody, if they break something, anything that happens, the landowner.
Shoot holes in the propeller or something, you may have to.
$3 million. So yeah. So that causes me for concern. So that's one thing that if somebody brought this document to me, I'd say, we probably should take a run at fixing that. And if you choose to do it with this clause, do it with your eyes wide open. I mean, you have free will. Everybody has free will, whether or not you're going to do a contract. But, those are the things I look for. The next thing I look at is minerals. The people who draft these apparently don't know that we have a split estate in Montana, and most people don't own their mineral rights. So this mineral clause on page 6, 7.7.3 says landowner shall inform grantee of the status and location of all oil and gas and mineral exploration and production activities on the property. Now, do any of you know that? And I mean, how many, I think it's a small percentage of landowners that own the mineral rights. So I would not want anybody who I work for to sign a document that says they would do that, because I don't know how they know that if they don't own those rights. You understand? Does everybody understand what I'm talking about? Okay. This one, confidentiality, is written in all caps. And it says that the landowner shall maintain the strictest confidence and shall not publish or otherwise disclose. Well, I don't know any landowner, so I'm good.
Question.
Yes.
So, one of the things, when the Keystone pipeline was coming through, eventually, a lot of the landowners that were gonna be affected by that Keystone pipeline got together and they negotiated as a group. And this wound up working out pretty good, both for the landowners and the Keystone pipeline, because they didn't have to make a deal with every single individual. But this wind deal kind of craftily came in and had the boilerplate contract like you have in your hand and told each individual person, well, do you want to sign up? And then there was confidentiality that maybe they weren't supposed to group up with their neighbors or talk to their neighbors about this. And that's like a huge red flag. The first thing you need to do is get everybody in your little area together and say, what do we want to do about this?
Well, here's how you do that, because I worked on the Keystone Pipeline for a group that was created by Northern Plains. I've also worked for a group of on wind contracts. So here's how you do that is, number one, you group up and you hire an attorney. Because if you're talking to me and I'm talking to them, I can't tell you if you have different deals, but you won't have different deals. The wind company is going to give you all the same thing. So I can only, if I work for a group, everybody has to get the same thing. And I can't tell if anybody gets anything different, but I've worked for multiple groups and usually they like that because, you know, they actually, the other thing they don't tell you, but the standard of the business is when you hire an attorney, they pay my fees. It's up to a reasonable amount, but I don't ever get to the reasonable amount because I do too many of them. I'm too fast. That's what I would do. And you don't hire the attorney that they send you to. Okay, does that help? Okay, and I'm not necessarily looking for work. I mean, I'm still working, but I will, you know, I'm here to educate you and I may or may not be in practice in a year or two, so.
May I?
Yes, yes.
Thank you. Yeah, just so everybody knows, I'm Will Connolly. I'm with the Terry Tribune. I also work with Glendive Range Review. Wind is my beat, industry in general, but it's been all wind all the time. Would you say that, yeah, would you say at all that the any confidentiality clauses that you've encountered in, let's say, this county and neighboring counties, would you say that due to any confidentiality clause in those private contracts, would that be a reason for why I have heard so little from
Yes.
those landowners who have contracted with, say, NextEra Energy or VIP or anybody else?
Yes, he's asking me confidentiality. I would advise you, if you sign this, that you should abide by it. And not just because it's a contract, because it's your word. I mean, we wouldn't need contracts if we were all angels, but if I agree to confidentiality, I should keep it. So that is why, and I think they have the right to that. I also think that, as Jackson said earlier, I think the reason that they can get away with hiring me, I mean, I negotiated on behalf of lots of groups for wind leases, is because it's before they sign. And it's more efficient for the landowners and the company to have one attorney. And it also helps me have more leverage to get you the best document. Because if there's 10 of you instead of one of you, and if I have the last person to sign, I have some leverage then, but everybody else might not get the good things that I get for that person. There are no clauses. A lot of times they have a clause in here that says that everybody gets the same thing. I can't remember what they call it. It's called something weird. It doesn't really seem to be what it is, but it's a clause that says that if they do a better deal with someone else, everybody gets the same thing. That's not in either one of these documents. But so there's, you know, you either want to be the last person and have a really good lawyer, then you'll get the best deal because they need you to get the project done. Or you want to group up. And if you don't want to do it, you tell them no early on. You know, why waste any time? You do not have to do this. My specialty is, well, I can't be a specialist as a lawyer. My niche is I do property rights. I do eminent domain. And right now in Montana, it would be a steep hill to climb for them to sue your place for anything that has to do with a wind farm. And that's because they have to be able to take property for the public good. You have to prove that it's necessary, it's a public good, and that, you know, it's the least amount of problems. I mean, I did litigate the case of them when they put in that power line to Canada. Maddle, I was the attorney that litigated that. I won at the district court and they ran to the legislature and asked them for a handout and they gave it to them. And they made it retroactive, I know. And so then I kicked their ass in court. Uh, So let me finish this and I'll come back to you, Lon. So eminent domain, they could make an argument, I thought it was bogus, but that they needed to build that, you know, from here to Canada. A power line that's internal to a wind farm, that'd be like saying, I get to take your property for my cows, you know, to be able to travel. So I would say it's a very steep hill. You notice I'm not saying can't happen. Litigation can happen on a lot of different things, whether or not it's going to be successful and whether or not I tell somebody that they should pursue it. Those are two different things. I'd say that that would be a very steep hill for them to climb to be able to take your property for any part of a wind farm.
Okay, and then just to follow up real quick with that, just to button it up so you can shoot the next horse, I guess, but would you say that, would you always, I know you're not giving legal advice, but normally do you give legal advice to say that confidentiality clauses should exist in these contracts?
Well, that's not legal advice. That's opinion.
Sure, opinion, yes.
Okay, so if I were working for the wind company, I would advise them to get a confidentiality clause because, you know, if you do a lease with your neighbor, I mean, I don't know, there's certain things that should be between the people who are doing business. And you as the landowner, before you sign it, you have ways that you can cooperate with your neighbors and others to be able to get the best deal that you can. So, you know, it's after you sign it that then you're not supposed to talk. So go ahead, Lon.
Yeah, you brought up the eminent domain here. So, there's a couple of my neighbors in the room here, and they wanna, the Lendi Wind LLC wants to have a power line that ties the Clearwater farm over here by Angela to the new proposed wind farm that'll be northeast Prairie County, et cetera, Dawson. And, that power line is probably gonna come across our place, maybe. And we're trying to determine whether they have the right of eminent domain to build a power line and connect these two wind farms, or do we have negotiation,
Leverage.
rights or whatever you call it,
Yeah.
possibilities, you know? Do we have to bend over for this power line?
I'm certainly not give you legal advice on such a question.
Yeah.
Having said that, you know, that I'm not giving legal advice. Everybody got that? Who is the entity that wants to put this power line in?
Next era.
Is it a wind company or is it a power line?
Well, so the actual power line is a contract. But the
But they're-
people that we're talking to work for Next Era. It gets a little gray.
Yeah, well, I'd say, come talk to me. Let's rumble.
Okay, well, and these folks that are talking to us, you know, they tell us, well, we've got the power of eminent domain, they say all these things, but not necessarily it's true.
Yeah, well, bring them to my buzzsaw. All right. Did you notice I did not give legal advice? Yes, ma'am.
Concerns of power lines, you know, down power lines have been the cause of lots of fires. And, does the landowner have the right to request a buried power line so they're not, so they don't have damage to their property later on?
She's asking whether or not landowners can request a buried line. You have a right to ask for anything, but they don't have to do that. And they do have eminent domain power if they need to use it. The new one that they put in around here, they did not use it. They did it all fair market. And I represented some landowners in that, and that was the best company I've ever worked with. Having said that, there is an issue going on at the legislature that really concerns me because of the fires and the problems they've had in California, they're making the laws easier. I don't remember the number, maybe 491, maybe House bill, that it takes away the liability for the power line. And they're making it so that if they have a plan and they do part of their plan, see, I'm sarcastic. I was definitely being sarcastic, that then they're not going to be held accountable. And I testified against it as a landowner. I'm a rancher's wife. I do chase cows some. And I went and testified against it because I think it's horrifying in Montana. And the insurance companies talked about how if it passed the way it was, that they wouldn't be able to insure us, you know, we'd lose more insurers. But then they did something about subrogation. And now we're talking about torts. That's not my area. And so the insurance companies are now for it, and it's in the Senate. And I'm very, very concerned about that. Go ahead, ma'am.
I testified against that bill too. I forget the number.
Okay.
It's a very bad bill.
Yes. Yeah. I was on Zoom. You probably were also.
Yeah.
Yeah. Well, thank you for doing that. But that is something that all of you, if you want to protect your property, find out what that number is. I think it is, I think that's the right number, 491. But, and, you know, let your legislators know that you do not want that to pass. The Republicans, for some reason, think it's fine. They've fallen in line that they got to help these co-ops and power lines. And I'm like, what about your ranchers and your people in agriculture? So. Okay, I better get back on task here. The other thing I look at is on page 7, 8.2, insurance. So this is how much insurance the wind company has to have. This company says they'll have a combined single limit of not less than $1 million per occurrence during the option term and $3 million per occurrence during the term. Now, let's say that this wind company has a problem with one of their power lines or a blade, and it comes down and it starts a fire, burns through your property and onto the BLM. And the BLM sues you for all the damage that it causes, as well as you lost your property. Pretty sure that a fire can cost more than $3 million in a blink of an eye. That means that that's all the insurance they have. So if this is an LLC, so it's an LLC that's been created that may or may not be fully funded. So your ability to collect damages. Now, if I do a wind lease or wind agreement, I don't think I did back when I did some of the earlier ones around here, but since fire has been such an issue the last 5 or 6 years, I put special language in that makes them liable and have extra duties about fire. And so if they have a fire, they automatically have to cover it. And so far, the companies have been doing this the last couple of years. They signed that document. So I'm extra careful about having coverage for fire damage. Yes, sir.
Would that mean though that they're limited to the damage done on the property they're leasing, or if the fire spreads beyond that?
I say that they have to indemnify you. Indemnify you means if somebody else comes after you, they have to step in and fight that fight. Those are you see now why these issues, anytime when you use the word indemnify, it can hurt you. And if you don't have enough of it, you won't have what you need to protect yourself. So I spent a lot of time thinking about where the paragraphs that talks about indemnity. So on page 8, you'll see it. We'll talk about it at the next one. They talk about, well, the bottom of, sorry, Jackson, bottom of page 7, they talk about removal of improvements. Upon expiration and termination of this agreement, grantee shall promptly remove all above ground improvements installed by grantee according to the by applicable law. In our other document that I'll talk to you about, there's a big restoration clause. And this does not say anything about restoration. It's called removing the improvements. And so usually if I work on a document, I make them do a baseline condition analysis. So they want to lease Lon's place. In 70 years, we're not going to be around to tell them how to, to tell them this is what it looked like 70 years ago. So I have a range scientist doing this analysis of what is the vegetation out there now. And that becomes the standard that they have to recover to. So we have a baseline and everybody can agree to that. And the wind companies actually like it too, because it's something certain and it's fair. And so any document that I do, I don't think I've ever had one that went out that didn't have that they have to pay for a range science to do a baseline condition, and then they have to restore to that. So page 9, number 12, mutual indemnity. Same word. I get really nervous when I see that word. This one says, each party that means a landowner in the wind company shall defend, indemnify, protect, and hold the other party harmless from and against all liabilities, expenses. Now you can just like add hundreds of thousands of dollars to that line, including without limitation, all reasonable attorney's fees, another 100,000, court costs and expert fees, losses, damage, claims, demands, suits, and actions, collectively the liabilities resulting from negligence, willful misconduct, or default of this agreement by the indemnifying party. We usually never indemnify default. I mean, that's a contract claim. And so this, for most of my contract, the documents I do, most of them, I would ask the wind company to limit the landowner's liability to $1 million. You do have a duty to indemnify to some point, because if you do something stupid and it impacts their position, but you shouldn't lose the ranch or the farm for it. So that is a really important one to look at, and I do not like this language. I got somebody's copy and they wrote something on this one paragraph, stinks. I did not get this from a person. I just got a copy. I just got a copy. So if somebody listens to this and tries to figure out, you can torture me. I do not know where it came from. Legal matters 19.6, page 15. This talks about each party waives to the fullest extent permitted by applicable law any and all right to a trial by jury. So I actually don't think this is a bad thing, but it's something you should do with your eyes wide open. So a jury trial means that we call in all your friends and neighbors and we go through a half a day of figuring out who can sit on the jury and who can't. Now, I love jury trials, by the way. But for this matter, I'm not sure a jury listening to all the arcane stuff about a wind lease, you're probably going to create some enemies. I think the judge would probably be fine. So if you have a decent judge, that's not something that worries me, but I always bring it up so that people know what they're giving up. You want a jury when you have something emotional. Ching, 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 no. Now I better not do a jury trial here. I'll be in trouble. So one thing that will come up is I know some people want setbacks. We're done with this document, Jackson. We'll go to the next one. They'll say, I don't want a turbine by my house. If I'm representing you, I may go to the wind company and say, my clients don't want a turbine in this area. We may put a place on the map where there's no turbines. Sometimes they want a mile or, some type of distance. So yes, you can negotiate for that. You could even try to take care of your neighbors and say, I don't want one within 1,000 feet or a mile of my neighbors. That I'm not sure. Note that this wind company, I just told you a little bit about what I know about the expenses. They're spending millions of dollars to put up a place, to be able to make energy and hopefully make it work. My understanding is there's very limited place. They'd have to go to, a limited place where you could borrow that much money for this type of project. So that's why the documents are always the same. And the people who lend the money for these projects, they can step in. If the wind company defaults, they can step in and take it over. They have to have that in the document to protect the lender. Because if each turbine costs $3 million and they're putting up 100 turbines, do the math. This is a lot of money. And so for them to actually get one move, on the ground, somebody's done a lot of work of putting a lot of money and capital together to make it work. And this is my understanding, 15 years ago when I was really working hard at learning all the ins and outs, it takes, a decade or two for it to pay for itself. But after it pays for itself, it's kind of like ching, ching, ching. So, but it is a lot of money that they're putting into to make it work. So. Yes.
I've got a question.
Yes, Jackson.
We talked a little bit about how to analyze the finances of these offers.
Oh yeah, I forgot to look at that part. Okay. So the way, did you have a question?
Yeah. My question involves, 70 years down the line, how about decommissioning, or what happens, if better technology comes around, they don't use wind farm anymore, then what?
Yes, and I'm gonna wait to hold that question. Tell me if I don't get to it, because there's a clause in the other lease, the other agreement that covers that. So that would be a better place to answer.
Good question.
Yes, so the way I'm gonna do this is, I'm gonna talk to you about fees, but I'm gonna do it in a way that doesn't tell you exactly what's in this document. Okay, so if you came to me and you had an agreement that had $5 to $7 per acre that they're gonna pay you during the option period, I say that's a pretty good deal. That's pretty, that's at the high end of what's normal. If they came to you with more than that, I'd say that's a lot of money. I've never seen that before. And they oftentimes, they didn't used to in the first agreements, but now most all agreements pay you a one-time installation fee per wind turbine. It's a one-time fee. And so it's for each turbine that goes in. If you said that they're paying me $3,500, I say, well, that's pretty good. You're in the ballpark. If you told me they were paying you $10,000, I'd be like, I've never seen such a thing. And I would actually, that amount of money that they were paying you would make me question whether or not the agreement was bankable, based on what I know about other documents. I could be wrong. I would just raise that flag to you to say, this company is so high that I'm not sure if when it comes time for them to go and get it funded. So let's say somebody's out shopping with you and they're like a miner, the gold rush. They're just trying to put together a project and then they're going to flip it to someone else to make money. They might not be as careful about, and they may not know as much. I mean, I want a company that will stay with you from the time that they do business until it's developed, because then you know who you're working with and you have an agreement, you've met people. It may not be the best, but to me that I have had developers put together a deal and then leave my clients high and dry and then try to come back in with someone else. And I don't think any of those deals have worked, the ones that I've worked on. Yeah.
So are these deals typically transferable? So let's say company A, they're really kind of in the business of getting these things established and maybe selling them to a utility or some other entity. Would that deal that you have as a landowner transfer to the new one?
Yep, and you can't, you have no rights. You don't have any rights to say no. You just have to go to business. Now, they do have to abide by the contract, the agreement.
Right.
But it is transferable for them, and for you, it runs with your property. Yes, Lon?
So on the same deal as his question, if someone files bankruptcy, can the judge change that contract at all?
No. Yeah, so if you could change it in bankruptcy, no, it is an agreement that runs with the property. It's an easement and a lease, remember, it's not just a lease. It'll abide by the terms, and if they lose the property, it'll go with the property. It'll be valued. So if you have a wind farm and your property gets appraised, it will be appraised with the wind farm. So that will include the income from the wind farm. And then it would, they would also have to take into account, imagine a wind farm might, change some things that are usually valuable with land, but that would be an appraiser's job to appraise it, but with the wind farm. So,
But if the thing isn't working, let's say that you can't sell the power from that wind turbine. Can you get stuck on this deal like that? I don't know that's ever happened. I know some wind turbines have been abandoned, but I don't know what happened to everybody involved when that happened.
well, in my experience, I have not had any of the, to my knowledge, nobody's come back to me and said that anybody's left them high and dry with turbines. The turbines are just too darn expensive. I mean, all the clauses in that contract, there's like 3 or 4 pages that I didn't talk to you about. There's all mumbo jumbo about whoever loans them the money can jump in and fix it. So those guys are very well protected so that they don't lose their investment. And And, most of these wind farms, are set to go for, 70 years. So those ones I worked on 20 years ago, they have another 50 years. Yeah, so I don't think we know for sure what will happen at the end, but I will tell you about the restoration clause that's in the other document, which is one that I written and I like, so. All right, so the other way that they're gonna pay is in the 20 years ago, they pretty much only paid you a percentage of gross revenues. And now on both of these documents, they're paying per megawatt. And so if that turbine is a 2 or 2.5, megawatt, I don't think they're putting up, I haven't heard of any 3s. If you heard of any 3 megawatt,
These ones that will be in this new wind farm will be 3 to 3.5.
okay, so we're getting bigger, 3 to 3.5. So for these ones, if somebody were gonna pay you $2,500 per megawatt, I'd say, yeah, that's in the ballpark, a little low. If they offered you 5,000 per megawatt, I'd be like, geez,
What was that first figure, sorry?
2,500.
Thank you.
If it were higher than, if it were 5,000, I'd be like, wow. Makes me again, I would wonder if the industry had changed a lot when I slept last night. Or whether or not the project is bankable.
And that's per year, isn't it? Like 2,500 per megawatt per year?
Yes.
Okay.
Now, with a lot of those gross revenue ones, my understanding when we run the math on how they were selling power, but again, that was 20 years ago, but it would get you anywhere between 18 and 22,000 a year per turbine. So if it's 5,000 per megawatt and it's a 3.5, you're all of a sudden kind of in that same price range. But these are things I would look at. I'm not saying it's absolutely true. I would just say, based on my experience, I'd question. I'd look deeper. I'd want to look under the hood and I would want to check out the company. No, because remember that all the calculations we had when I only do stuff on the front end. So they give me a pro forma or an estimate. And so I think that it would be in the same range, but the ones that pay 25 are 3, most of the documents I used to do were the greater. You either got a gross revenue or you got the per megawatt, and it was whatever is the greatest one. Now, both of these documents are only paying per megawatt. So that's something that I don't remember seeing before. I have seen one of these documents before. So that must be, they must go back and forth a little bit in the industry, how they pay. I think it's in the range, but, and it also, if you're gonna get paid by gross revenue, it depends on how much you're selling electricity for. Because you're just getting paid, it's like, if I lawn, sends his cows to market, he has to pay the trucker, and so there's certain things that, like the wheeling charges, when they get to cut that out from the amount because that's what it costs them to get it to where, so there's all types of things, but it's harder to calculate. I think that's one reason why gross revenues is hard, because who's ever going to be able to look at their documents to see whether or not they paid us enough, right?
Well, just to clarify, you said this would be a yearly payment, $2,500 for the entire year, or
Per turbine, per megawatt.
per megawatt, but is the but it's a yearly payment, so this tower gives you $2,500 revenue.
It's at least a 2.5. It's probably a 3.5. It's like, let's say it's 3.
Yeah, but I mean,
70.
still, it's only a year.
Yep. Yeah, so yeah, it's, if you get a whole bunch of them, it can be good money. And I did the best deal I ever did was a rancher down in Wyoming, and they had 2 companies fighting each other. And I had them at the end, the one who won it put in 2 new wells with windmills for my clients. So they got water development. That was the kicker that pushed it over. But they gave them all this upfront money and then they never built. It was like, woohoo, paid off that loan. So
if you're a landowner and you're looking at one of these deals, could you also see who they're gonna sell the power to before you agree with the contract?
I would want to know that, because it gives you an idea. I mean, I would want to ask questions so I could do my best to ascertain who I'm doing business with and whether they seem to be equipped to do business here. And, you know, if you're talking to the landman, their job is to get you signed up. They may or may not know that much about their company. When I did work with that power line that they're putting in to go east, the people that talked to the landowners and me, I was in the end. I like being the last one because then I get better stuff. But they were awesome to work with. It was not the typical landman. I mean, there's sometimes they send me people and I'm like, really? Like, can I talk to your lawyer?
Would the lenders wanna know that too? I would think the lenders would wanna know.
Yeah, but remember the people who you're doing business with, if it's somebody who's putting together a speculation, they won't have talked to lenders yet. I mean, a company that's built other wind farms, they've talked to the lenders lots of times. So in this time, I probably err on the side of, I want to see a track record of somebody who's built other wind farms, because that gives me an idea of who they are and what they do. So the other thing I didn't tell you about is sometimes, you know, with wind farms in Wyoming, when they first started, they'd go out and they'd leave all this trash on your place where they're building. So I have a sheet sometimes, a couple pages that we add all the things that they can and can't do on the property. So it's an agreement about protects the landowners when they're out there. And no hunting, no dogs, no drinking, you know, careful fires, you know, if you're in an area that's sensitive to weeds, wash your tires. I mean, we can do lots of different things like that so that it doesn't end up being a big problem.
How about close the gates?
That's a good one. Yeah, close the gates. Or else. Yes, sir, in the back.
What's typical payback on? Once a year?
For them,
Yeah.
I think it's years. I don't remember exactly, but in the back of my mind, and remember, I looked into this, you know, a decade or 15 years ago. I think it's at least 15 years. But I would ask them that question. I mean, whomever you're dealing with, if they don't know that, tell them you want to talk to somebody at the company who knows. You have a right to, you know, to know who you're doing business with. You could have a long time relationship, and maybe longer than your wife or your husband. So I'm now going to look at the 2018 agreement. And this one also says wind energy agreement. It is not an option. So but they had some time to build. So that usually they have to have time after they get the agreements to be able to do all the due diligence, the environmental and all that stuff to make sure that they can, and to test the wind.
What's the approximate turn time? How long does it take for them to get up and running?
Jesus. Depends on how many turbines, right? I mean, I think the fastest they could build one with, now I'm just really spitballing. So if I'm kind of blowing smoke, I'll tell you, I don't know exactly, but my best estimate would be if they were building, say, a 30 turbine wind farm, and it depends on road building and all that. Note that to be able to get the machine in there that puts up those, it's a crane that puts up the turbines that they use. It comes in on 4 trucks, I think 4 semis, and then they have to put it together. So they have to have really good roads, and they have to have a really good turning, you know, on the roads because of the big equipment that they use. But, and they pour concrete, and the concrete is, I think, 8 or 10 feet. Underneath those, they pour pads. You know, it's a big construction. So I would imagine it would take them at least a full year and possibly longer. I know that once they start building, putting up the turbines, they try to get it done in a season. And the reason I pay attention to that is because sometimes I have to negotiate for my clients where they calve or where they put the turbines. Because as soon as they can start building in a year, they're going to want to get out on the ground. And so there are things we can do like that so that anybody who wants to keep running their ranch, we can do creative things. You know, if they have to, they can buy you pasture, or, you know, we could say when they can be where, or we could use some type of fencing so that, because you don't want your cows in the construction. They don't want your cows there either.
I can offer some perspective on that. I climbed the wind towers during the construction phase of Clearwater 2 in 2023, north of Mountain City at Rock Springs and Angela. And I know that they started Clearwater 1 in 2022. Clearwater 2 was 2023, which crossed the Highway 59 over there. And then they were up and running in 24. And that was about anywhere from like Clearwater 2 was 112 towers. Clearwater 1 might have been bigger. So we're talking in the neighborhood of 200 towers. We got it done in about 2 years, 2.5 years. And the word on the crew lot was we just want to get them vertical.
So that, you know, they got a couple hundred towers up in a couple years. So that, you know, I know that they try to get it done in a season. But note that they were probably out there putting in roads the year before. So you're gonna have construction on you for probably activity for 1 to 3 years. Because after they're up and running, they're also gonna be there a lot at first too, for bugs, anything that doesn't work. Yes.
We had lots and lots of trucks carrying gravel and equipment going up Highway 59.
Yes, so lots of trucks carrying gravel. I mean, it is a big construction project, and they will, if you want upgraded roads, they will upgrade your roads because they have to be able to, you know, bring in that equipment. And they'll build roads across your pasture, because wherever they put up a turbine, they have to be able to get that big crane there. So on this document, Jackson, we're gonna go, it is a wind energy agreement. It's a easement agreement. So it doesn't say lease on the top. I'm less concerned if it says easement and it leaves out the word lease. If it only says lease, I say rookie. So the first thing we look at is on page 2, indemnity and insurance. This one says that the wind company will carry 1 million per before the start of construction and 5 million afterwards. So usually I'm going to want a higher cover insurance for the wind company than 3 million. This one has indemnity, and it says the grantee is going to indemnify and hold the landowner. So this one has, in this part of the lease, another place that talks about the landowner, it says that they will indemnify the landowner. And it says they will, for any third-party claims, actions, lawsuits, fines, injuries, or damages of any kind actually incurred by owner for physical damage to property or for physical injuries to any person, extent arising out of the installation, operation, maintenance, removal, or abandonment of the wind power facilities. So that's, you know, a reasonable language to protect the landowner. On page 5, on 7.8, this is where it has baseline condition. It says prior to any construction on the property, grantee shall hire a range professional acceptable to owner to prepare a one-time rangeland assessment to document the baseline condition, including forage density, forage type, and list and location of noxious weeds for those areas of the property in which grantee intends to construct the wind power facilities. So this is what they have to restore to. So this is something that protects the property after we're all long gone. So next I'm going to go to page 8, that magic scary word, indemnity 8.7. And this one says, owner shall defend, indemnify, and hold grantee, that's the wind company, harmless from and against any third-party claims, actions, lawsuits, fines, injuries, or damages of any kind actually incurred by grantee for physical damage to the property or for physical injuries to any person to the extent arising out of the operations or activities of owner or owner's invitees. So anybody you invite to your property. And that means that the landowner will have to defend the wind company and pay attorney's fees. And they say this indemnification shall survive the termination of the agreement. Usually I try to add a sentence to that that says it's limited to $1 million or the landowner's insurance. So that is a place where this one isn't badly written, but I would try to limit it if I can. On page 9 of this document, it talks about soil restoration, reseeding, and weed control. Do you remember on the other document, we had none of that language, we had removal of the improvements. So very different concepts. This document says that they're going to remove, if they remove or destroy vegetation, that they have to plant it back. And then upon completion of construction, they're going to restore the soil surface to anything, to what it was prior to the baseline condition. it also says that they're gonna replant native grass seed, so they're supposed to go to your county and figure out what that native grass seed is or what it was in your baseline conditions. And then they have to take, this one actually has a duty of them to clean their vehicles before they enter the project. So this one's pretty serious about noxious weeds.
This may be a side question or an end of the thing question, but is there any clause you wish you could, by standard operating procedure, put in these private contracts between landowners and industrial energy companies that you wish you could put in there, but you think it's gonna scare the company off?
Did you ask me about one coming here and I said, I don't think we can get it?
Talked about aircraft protection lights, we talked about ice throw. Talked about setback.
Yeah, so I think it's, you can get almost anything
Bonding from construction.
bonding from construction time on. I don't think you're gonna get bonding, because note that those turbines don't pay for themselves, we know for, possibly up to 10 years. And so they're not gonna, nothing should go wrong in that time frame based on what usually happens with them. And all their money is pretty tied up into just getting the project up and running and servicing their debt. So that, I don't think it's necessary, and I don't think you're gonna get it. And if you want more bonding, I think you should do the legislature. Well, Montana has a law about that, and that's a better way. If you try to get it in contracting, I don't think you'll get it. So, Lon.
So, Nextera, Wind LLC, has what's called a development agreement framework. And they did offer to bond from point of construction, if the county commissioner signed this development agreement framework. But their angle on it was they wanted a $10 million a year tax decrease. tax
Right.
abatement, and then they would offer these little, and so do you know what bonding costs? for-
Yeah, it costs whatever number the number is.
But I mean, we seem to have a heck of a time figuring out, what is that number to decommission a 3 megawatt, 575 foot tall wind turbine?
I don't know, but I wouldn't, now this is my opinion. You're not paying for it, so take it accordingly. It's not necessarily a legal opinion, it's a practical opinion. I would not wrap myself around the axle about bonding. That is not where you're gonna get big benefits or big downsides. We have a statute that covers bonding, and I happen
15.
to believe that that's soon enough. So I think we could fight over a lot of things. That's not where I would keep my powder dry on that one. It is certainly not worth $10 million. And so I think that, in that one, like if I were the company, it's like, oh, hell yeah, I'll give you that. So that was, that I violated my principle. That is advice, but note it wasn't legal advice. It wasn't about, everybody saw that, right? Okay. I don't have malpractice insurance for that, so. Page 18, 12.3, effective termination. This is it's more than almost the whole page. So this is what has to happen in a good document about restoration. It says, at the termination of this agreement, at any time, so anytime it's terminated, they have to remove, raise, and demolish any wind power facilities that are above the ground, and to the extent below the ground, they're going to remove it to 2 feet below the ground. So where those places where they have those concrete pads, apparently they're supposed to cut off 2 feet of those. I don't know how it's going to work, but they have to haul away and dispose of all removed concrete and other waste materials in a lawful manner. They have to reclaim and restore the land and the surface of the property to a condition and the forage density reasonably similar to the original one that we saw in the baseline condition. They have to plug and abandon any water wells drilled by grantee. That's something I didn't mention. If they're talking about anything about water, or if you have water lines, that's something usually I put in special for a landowner that has that, so that we make sure that any of their building will not impact your water development or your water. They don't get water rights with this document, okay? So if they're taking any or they want some, it's like, oh, no, that's a different deal, and you have to be a beneficial use. They have to cause all liens and encumbrances to be removed, and that and if they don't remove it, they have to have an adequate security posted to cause the removal of such liens and encumbrances. So they can't, pretty much, they have to leave your property the way it was. It says, if grantee fails to remove such wind power facilities within 18 months of termination of the easement, or such longer period as the landowner may provide by extension, owner may do it themselves, in which case the grantee shall reimburse owner for reasonable cost of removal and restoration incurred by the owner. I have been told that if those wind turbines and what they leave there, that what is there, the salvage value of it should compensate for the cost to remove it. I have not tested that, but I've been told that from multiple sources. So
Would the salvage value equal the cost of the move?
it should be equal, it should be greater, it should compensate the landowner for doing that. That is what I've been told. I have not double checked that. I'm not going to talk about the terms in this one, because when I talked in general about the other one, I gave you a general range that covers what's in here. So, do you have questions for me, Jackson?
Do you want to cover some of the questions that we got ahead of time?
These hard ones?
Yeah.
So, is that person here? Well. So, with, this one says with type 1 zoning, but I don't think it matters what type of zoning. So the question is, with zoning, how does it affect people that are leased to a wind company? Well, it depends. And that'll be $500. That's how I practice law. No. It depends on what stage the wind company's in. If the wind company has already built, zoning won't affect it. If wind company has started construction, I think they have an argument that, you know, they're making their investment and they've already got their property right. If they just have a document, you know, the further you get away from up and running to just having a lease, the more the litigation slants towards them.
Zoning entity?
Yes, towards a zoning entity. And the closer it is to being up and running, the more it goes this way. But I'm telling you that in this room about litigation, it will be an interesting case. And both sides, if you have to pay your attorney, you're going to pay somewhere between $100,000 and $300,000 to litigate. And it's a legal question that I cannot predict. You know, the closer you are to just having an easement agreement, and if you're up and running, we know that those forest spectrums are probably safe one way or the other. You're certainly safe if you're up and running, that you can't be prone to zoning. Because the idea about zoning is, in America, you know, the government, we have constitutions at the state and the national level that say nobody can take your property. Now in Montana, we give some eminent domain authority to private entities for public uses. But most of the time, it's only public entities for public uses that can take property. But you can't take property from another individual and not pay for it. So zoning is a kind of an interesting, because it's the type of regulation or changes to the property that are closest to the people. So it gets a little bit of a, you know, if somebody owns your property, they say you can only build 4 houses here, blah, 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 blah. And you come to me and say, is that a taking? And I'm like, well, did anybody ever tell you could build 4 houses? I mean, probably not. I mean, the closer it is to your local area and its zoning, the harder it is for me to find a taking. However, at some point, if zoning treats one business different than other businesses, say wind farms can't do this, but everybody else can, you then might be guilty of what's called an exaction. It's another type of taking. You can't impose regulations that limit property rights on one entity that are different than other people and treat them, make them pay more than the damage they're causing to the community. So go ahead.
So one of the big things that you're explaining right now is some proponents of zoning say, well, we'll give the county commissioners the opportunity to grant variances for certain projects. And we're getting into this deal that you just explained where, somebody might not like the wind company, so the county commissioners say, well, that development, we're not gonna grant a variance. And then somebody might wanna sell that, say, and the commissioners say, oh, we'll grant that variance. So now you've done just exactly what you just explained there. And I don't.
Have your attorney on dial up. I mean, just have the number built in.
Yeah, but this idea of people who are proponents of zoning, that this variance can, give them what they want. and
Inoculate-
lock out what they don't.
Inoculate you against a taking or against litigation. I would not, if you were paying me for legal advice, I would not so advise.
Yeah.
The next one, is a 2-mile setback and limiting the height of towers within reason due to the fact some of the land is leased to the wind company? You might be able to negotiate a mile. I'm just giving you practical now, it's not legal. I'd say 2 mile is more than they can stomach, because remember, their ability to make this work financially is they have to have a certain amount of places to put turbines, and they have to do all the testing to see where they're gonna put them, to see where the best wind is. So you start limiting things. Yeah, come and pay me all this money, but don't put them here and don't put them there and be 2 miles from this and 10 miles from that. I think it's not unreasonable to ask for 1 mile. I think 2 mile is a lot. And then the heights of towers, I don't think they'll negotiate with you with heights of towers because they need a certain height to be able to get in that sweet spot for the wind that they need to be able to pay for.
Taller the better, for them.
Possibly, I'm not sure that's always true. They're gonna measure with those Met towers where the best wind is, and they're gonna try to be in that sweet spot.
You say a mile from home, a mile from property line?
I think a mile from a home, I've seen that done. I've never seen a mile from a property line.
NextEra is currently offering a mile from home, 632 feet for their 575 foot to apex towers from property lines. That's 110% of the apex height.
So yeah, that's not very far, not a mile. Yeah, and I think they're really hesitant to do anything more than that because when they contract with you, they don't yet know where they can put turbines. And I haven't worked for the wind companies, but I do understand their business model some. And so I think that they're gonna safeguard all they can if they spend all that money to be able to get a place where they could make money. I've already sneezed.
Back to what you said earlier, and map.
Mhm.
And say you want to preserve your view shed, or you want to protect your neighbor, or whatever, you could get a map and negotiate with the wind company to say, we don't want turbines in this area, we're okay with them here.
Right.
Also, I mean, Hertha said this a bunch of times, you don't have to sign a contract at the end of the day. You know, if you don't feel like, I think that was the first piece of advice is, when you get one of these contracts, go get a lawyer, go get a good lawyer, don't get the one that they pay you to go to, you know, go get a good lawyer and make sure that this works for you, you know, don't just sign a contract because you see dollars and you think it's gonna be easy and that you're not at risk, you know.
There is no free lunch. That is
Some
my
of the people
advice.
that signed contracts with Perry County were mindful and didn't sign up the land that was within such and such a
Mhm.
distance of their house, right up front, so.
That is, many of the landowners who live on their property, we do usually preserve area around their house and the view shed, you know, and they're certain enough about it. It's like, no, if you have to build there, I don't want it. And if they have a good enough place, the wind company's okay. Now, no, they don't want to put turbines in coulees. They want to put them on, you know, on a higher place, you know, but that's also hard to get out of your view shed, depending on where you are. What does it take for a wind company to be grandfathered in while zoning is still being done? I think what we talked about earlier, if they're already built, then, you know, I'd say they're grandfathered. When you start moving away from that, it becomes a little bit less and less, and you're in the middle, both attorneys are gonna love it because it'll be a heck of a fight and nobody knows how it's gonna turn out. And I don't do any litigation now. It doesn't matter how big or how small, and this would be kind of big litigation. I don't get to the courthouse steps for less than 100,000. So litigation is expensive, and that's not me wasting money. That's what it costs and what I have to pay, you know, the people that help me to get litigation is hard and it's expensive. And, you know, if you're gonna get in a fight, just know that you've tied yourself to a tiger and it's gonna cost a lot of money. Does a property owner with a residence get a tower close to their home have a recourse if they can hear it? No. We do not have any, you can't call for a nuisance for sound or view shed. I mean, a nuisance is something that's obnoxious. It has to be a pretty big deal. I guess if it was a high enough decibel, but I don't think from what I know that they're noisy enough that it would qualify as a nuisance. Certainly if it's not, if you put the turbine in yourself, but just saying. Who signs for zoning when land is under contract for deed? The original owner or the buyer with the contract? Whoever's name is on the deed would be the one who would sign for zoning if you're trying to get to 60%. So the person who's on the deed still owns the property, regardless if there's a contract for deed. All that means the contract says if they finish paying that they're going to get the deed, but the person whose name is on the deed is the current owner. This one I'm not answering. How would the corner law come into play if two of the corners are not in the contract? Can an underground or overhead line bench run through the corner? It depends. We just got there's that new case right now today that came down out of the 10th Circuit. I don't have any idea why the 10th Circuit's talking about corner crossings because they shouldn't be talking about Wyoming law, but I haven't read it. So I'd have to read that and really think about it. I would not answer that one on the fly. Is it better to keep the area small for type 1 zoning to try to do as much in the origination or add land later? You know, I want you to think of something. Zoning can be either a shield or a sword. You know, you could be using zoning because you don't like wind farms, and the next person could be using zoning to get rid of pig farms. I mean, we happen to have a right to farm law in Montana that protects us from things that can take agriculture away. But, you know, what you think is a sword in one thing can be a shield to protect you in one way. This type of law can be also used against you. So just be really aware of how you use it. I mean, zoning is meant to be that with the people that we live closest around us, we can all get together and agree on what type of land use we want. That is what it's for. So it gets a little bit of an extra, it's not as looked at as strictly for takings and affecting property rights because theoretically you can go to the county commissioner and you can talk to them and they're going to listen to you. I know it's theoretical. But it isn't a panacea. I mean, you could, people learn how to use zoning. I mean, there's lots of people in the state who don't want anything to do with zoning. So it is a way if you want to organize together and you have enough agreement that you could affect what gets done. So,
there's one thing about this zoning in Prairie County, there's a high percentage of federal land. And our zoning really doesn't tell the federal government what they can and can't do. We could sue them, but the litigation to sue the federal government can even be more expensive than suing a private company.
way more. They
Yeah,
do,
and
they don't.
so the folks who think that they're gonna keep windmills off of BLM land in Prairie County through zoning, that is very unlikely to happen.
I agree, and I would also say that it's unlikely that zoning has any impact on the federal government.
Yeah,
You could sue them, but if the attorney who took the money to do that, you want them to be very honest with you about your chances. And it does cost a lot of money. The federal government is incredibly hard to litigate against. I have two more questions and then we'll be open up to more general questions. Is there any recourse for a landowner for any damage to wells or other water supply after the wind turbines go in? Yeah, you know, they should not be impacting your water rights. That's a property right. And if you are concerned that what they're doing could impact your water rights, talk to your attorney ahead of time, because I sometimes put in special clauses But if I were your attorney, I could not know that unless you told me that. So I would ask you questions. Do you have any extra concerns? Where's your water development? Do you have any lines above ground? Do you have any lines below ground that this could impact? We would want to protect all of that, because the theory is that when they come and put up that wind turbine, they are paying you to have the turbines there. They're paying you to lease the ground. They're paying you for the access. But if they impact any of your other property rights, like your water or your ability to run your cows, they're not, we should make sure that they don't impact that. And that's why they also pay your attorney's fees, because it's not supposed to cost you, you're not supposed to lose anything in this deal. You're supposed to get compensated for them being on your ground to do their business. Last question, this kind of went to what Lon talked about. How does state, BLM, and nonprofit land affect the signing of the zoning? Do they count as a signature that is needed for 60%? Well, state and the BLM, they don't participate in zoning. A nonprofit landowner is the same thing as any of us. They just don't pay they don't pay the same type of taxes, but they still could be an owner for the signature to get 60%. So, are there any other questions? Yes.
Thank you. So just to recap the payment structure options options being the very first one, I guess, depending on if it's the contract. Landowners get paid by wind towers through what vectors and for how long, if that makes sense.
Once the wind farm is up in production, then now before as the turbines are getting built, when they're sometime in that process, they'll get a one-time fee for the turbines. That didn't, again, 10 years ago, I didn't see that very often. Now I see it in every document. So that's become the standard of the industry, to get paid a one-time payment for the turbine. Sometime in that process of them going vertical. And then before the turbines go vertical, you get paid per acre. And that's leasing your land while it's keeping it out of anybody else's, nobody else can talk to you about wind leases, and it allows them access to do their bird studies and to look where they're going to put roads and all the stuff that they have to do to be able to build. They have to do a lot of engineering. They have to check your soil. I mean, it's a big construction project. And so that gives them access to do that. And then once you get to when the turbines are up, you're going to get paid either a gross revenues. That's what it used to always be. I don't see that in either one of the documents I looked at today. Or you're going to get paid per megawatt. And it used to also be that you either got paid gross revenue or per megawatt, whichever was greater. That is not in the documents I looked at today. And if you don't get a turbine and you've leased your property, sometimes they'll pay you per acre or per lineal feet for transmission lines. So.
Typically, how long is that, does a landowner, let's say a landowner lives infinity years, and then, how long does a typical wind tower last? That much I don't know.
They're going to keep paying you as long as they're out there, as long as the contract, until they remove things. Now, if you have, let's say you're in the option period and they never build, you still want to, if they don't build and they've gone beyond their years, you want to do the legal work to get them removed. Once they have this easement document, there's a short form, and it gets filed at the courthouse, and it's with your deeds. So they have an interest in your property, puts everybody else on notice that they have that. So at any time that this, you want this to pass on, however you pass your property on, you want, like you passed it on to your kids, you want them to know that if they don't build, or if the wind lease expires, that you have to do the legal work to get them removed from the property. The other question you asked was, how long do the turbines? My understanding is the turbines, now they're building brand new ones all the time. They figured they were going to last for, 20 years. I don't know if that actually happened. And note that, a lot of the turbines they first designed weren't designed for our wind in Montana, because it gets a little, up and down and pretty intense at times. So I think we're just now really going to be learning how much they're going to have to replace them and how long they last, because they really are testing them in the field, literally in the field.
About 5 minutes, so we probably need to wrap up. So
5 minutes and then we wrap up, because it's like an hour past my bedtime.
there's There's a couple questions on Zoom, and since it's a reasonable number, I might just shoot a couple of them
Sure, Jackson,
at you.
sure.
So if a wind company bankrupts within the terms of the easement and lease, who would be responsible for the removal of the turbines?
Number one, it would be very hard for a wind company to bankrupt. I mean, they might go bankrupt, but this document provides all types of protection to their lenders. It's built, this whole everything is, the whole deal is built so that the lender can step in and start running it. So, you know, their plans are that it never goes bankrupt. If it goes bankrupt, let's say all things fall apart, you know, it's still the legal duty of whoever went bankrupt, but you can't get,
Let out a term.
yep. I was just thinking about,
That's what bond is for.
that is what the bond is for.
It's also like that contract that says the landowner has to do it themselves. They will be compensated.
They can use the salvage value to help pay for that. You get to what's left, yes.
One scenario that's been run at us is, sometimes foreign companies can buy into these things and they are not bound by the same laws that US companies are bound by. Have you heard this or?
No, I don't believe that. If you do business in Montana, you're bound by Montana law. I mean, and note that this, you know, you could look at that. I mean, they're almost always going to have a Montana, you know, an LLC can do business here. You're not, even if another company owns the LLC, you're doing business with the LLC. No, if they're doing business here, I mean, they are bound by Montana law. You might have a hard time finding them to sue them and to collect, but doesn't mean they're not supposed to follow Montana law if they're here doing business. They don't get an exemption from that, so.
Another question that probably requires a follow-up with you personally is, what are my landowner rights regarding a power line if a lease was never signed and they want to cut through to save on dollars on their ends? They continually call and ask regardless of telling them no. We have no interest, nor have we ever signed a lease. We have opted out. They're a private company, they have leases all around. They should not be putting up power lines on leased property. Should they not be putting up power lines on leased property they already have? It seems they don't plan ahead, they forward. So what are the landowner rights if you're the last person kind of standing in the way?
You always have the right to say no. I mean, we all have to say no at times. I mean, I have to say no for sometimes taking on clients, you know, so, you know, practice no. You really? No. And, you know, you can tell them not to call you, you know, or if you decide that, you know, maybe no, but if you gave me this much money, you know, but sometimes I've had people say no until the number was right. But sometimes no means no, so.
And the follow-up to that was, even if you say no, they threaten eminent domain, which is what we kind of talked about.
Yeah. That if they're threatening eminent domain, then please call me. My number is 406-599-5154. So I can help you. I give a free consult for a half hour. I'm not trying to make money, but I don't like people threatening eminent domain and bullying people. And I do understand that issue.
We've got time for one more question. Yeah.
Yes.
So maybe not in this area, but I'm super curious about military transports and how like with helicopter escorts going up and down to whatever they have going on there. When you have that third party in that conversation, the confidentiality in that contract, and how does that work with that conversation? Because obviously they've got their interests and priorities, but proximity to towers and easements.
Are you talking about the confidentiality with this agreement?
Yeah, like if you're not allowed to talk about it or anything like that.
Well, you can talk about that you have a wind lease. The fact that you have a wind lease will be on public record. It will be filed, you know, with your deeds. It won't have all the details, but the fact that you have a wind lease, you can talk about. What you're not supposed to talk about is how much money you got paid and whether or not you got a limit on, you know, the specific terms. And the only time, you know, they may tell you not to talk about it ahead of time, but until you sign an agreement, you don't have an agreement. But if you signed the agreement, and you said you'd give it confidentiality, I would advise you to do that because you said you would. And, you know, again, I always laugh at the confidentiality. It's like, what are they gonna do? Take away my birthday? But I think you should still abide by it. All right, thank you so much for being such a great audience. Thank you online.